Welcome to Immigration Uncovered, the DocketWise video podcast. I'm James Pittman, your host. And today we're going to be talking about business immigration under Donald Trump 2.0, and specifically what's happening with some very important business immigration categories like the O visa, the P visa, and also the EB-1 immigrant category. And I have here an outstanding employment-based immigration attorney, James Hollis from the law firm of Siskin and Susser out of Memphis, Tennessee. James, welcome to the program.
Thank you for having me. Nothing going on in the world, so glad we could be on such a calm
Yeah,
podcast.
it's such calm, uneventful times that we're in right now. So, James, let's talk a little bit first, just by way of introduction, about your journey into immigration law. Why you chose immigration? Yeah, I'm sure you could have done lots of things in the law, and why focus on sports and entertainment specifically?
Oh man, I feel like first of all, I'll say it's a privilege to actually be in the sports entertainment practice. That was not where I thought I was going to end up, and it's not sort of where I started either. I graduated from WashU in St. Louis in I don't know 2012. It still wasn't a great time for lawyers around then. Like it was post financial collapse. The big law situation
Right.
was not
Right.
amazing.
Mm.
They were not folks were not recruiting. And I was not very good at actually, figuring out what I wanted to do after law school. Like, I had a very good immigration professor at law school. I clerked for an immigration firm in St. Louis for a little while, and then I actually went to China, to teach English after I passed the bar, which, at the time, I was like, "I'm never gonna be a lawyer. It's fine." And then I came back and, went to Charleston, South Carolina, and was working for, like, a removal defense, like, family-based immigration type firm, and I wasn't really enjoying that much. I kinda wanted to do, business immigration, but I had no one who I knew who was a business immigration lawyer. I it was not something we really covered in law school. I just happened to my brother at the time, was, engaged with a lot of, entrepreneurs, and one of them had gotten an O-1 visa. And we decided, hey, let's be idiots, and we can start a business in which we're going to provide legal services to like location independent entrepreneurs. And this guy gave me a copy of his O1 visa packet. I then took it and filed my first O1 for somebody else, got it approved, and sort of the rest is history. But I met up with Greg Siskin a couple years later, and he offered me the opportunity to come to his firm, and so I took it. With regard to the sports and entertainment stuff, I certainly I got my start in like entrepreneur immigration. That was sort of the main focus of my practice for a while. I I started to get into the more O's and P's situation, as my practice developed at Siskin Susser, sort of the Siskin Susser, the first period. And then I happened to meet an attorney at an AILA conference who did a lot of sports immigration. And I'm a soccer obsessive, and I have been a soccer obsessive for many years. And I just happen to know a whole lot about soccer and internationally and in the United States, so we hit it off. And went up to his firm in Washington D.C. for a couple of years, and then managed to come back down to Siskin Susser, and continue with my sports and entertainment practice after that, and sort of grown more on both sides, both the sports and the entertainment side.
I agree that it's really a privilege to be in that niche because you're dealing with amazingly talented people, and it's inherently interesting, sort of getting the visas for these people, and dealing with the specific issues that you have to deal with these type of cases in terms of their reputations, their achievements, their accomplishments. It's just a good time all around. I mean, of course, it has its frustrations like any other profession, but I mean, in terms of niches that you could occupy. Sports and entertainment really it is a privilege to be in
I
that
you
niche.
know, I agree. I think the way that, I tell people about sort of what I did in the past Trump administration, I kinda felt bad because everybody else was sort of, taking on water at all times, doing H's and L's and everything, where, most of the time we were getting taken care of fairly easily. It did sort of strike a chord with me when, a lot of the visa bans went in, and, professional athletes were able to bypass those visa bans, um, while, family members were like, not being able to see each other, medical professionals not able to get into the United States. It was an absolute, mayhem trying to get visa appointments and get, national interest exception waivers. But, the pro sports, teams that I was dealing with They were fine. And I thought that was a little bit of a disconnect and thought that was strange and hope I don't have to experience that again. But I do think it gives you a sense of how certain like areas of in immigration law are treated a little bit better than other areas, which I think we're going to go into a little bit more as well.
There's a certain amount of, sort of, deference and privilege accorded to certain of the categories.
Oh, absolutely. Yeah, I mean, I often tell people that, like, if I have to, like, sort of leverage a business issue to get somebody a faster visa appointment or to get a faster adjudication at USCIS, it's a whole lot harder, whereas if I go to them and say, "Hey, this person, or this person is needed at this show on this date.
Right.
They're going to lose this much money if this happens." It's much easier to sort of motivate change or motivate, like, a processing decision than it would be if it was like, "Oh, well, look, I gotta come here and close this deal for my bank, and, it's gonna be this amount of money." It's like, "Well, why don't you just do it on Zoom? You don't have to." They they don't need you. They don't need you physically present in the US. There's a whole you have that sort of, extra, I don't know, angle because it's like, "Okay, well, if this person's playing a sport, like, nobody else can play that for him," you
It's
know?
personalized.
Yeah. And it also I feel like it also makes everybody, like, a little bit, more interested because it's like, "Oh, you play for who? Oh, that's cool. I might see you on TV." It's like, yeah.
Right, there's that familiarity and the fact that everybody likes entertainment, and practically everybody likes sports, most people do. So there's that familiarity. Yeah, it's all true. It all goes into the mix. But let's talk, just go through some of the, the essentials of the different categories. So you're working with regard to sports and entertainment, we're talking mostly about OP visas, and then for permanent immigration, EB-1. So can you just give us sort of the nutshell version of the distinctions between them and their essential requirements?
Sure. O1 visa, easiest way to remember it, there are basically 3 types. There's the O1A for, sports and for, science and for business and for education. There's the O1B for arts, and then there's the O1B for the motion picture and television industry. The motion picture and television industry is supposed to be the highest level of O1Bs, followed by the O1A, followed by the O1B arts. Generally speaking, the O1B arts is processed quite reasonably. There are a lot of arts organizations in the United States that use it pretty frequently. O1A is used by all sorts of things. Quite frankly, don't generally use it for professional athletes unless I have a very specific reason for doing so. Like sometimes there are activities that certain pro athletes will need to do that are better encompassed by the O1A than by the P1, which basically the P1 allows you to come to the United States and solely compete.
Mhm.
Whereas the O1, you can add some additional activities in there and add some additional sort of payment arrangements in there that are important. So that's frequently how it's used for pro athletes. Um, all of those visas are 3-year maximum in length. So that's O1 A, O1B, and O1B film and TV. There are some intricacies about how you can request for 3-year extensions versus 1-year extensions and all that sort of thing. But generally speaking, 3 years at a time, and you can extend them, virtually as long as the person continues to qualify and has a reason to be in the United States that qualifies.
Let me just interject two questions. O, even though it reminds one of the word outstanding, the actual name is extraordinary ability or achievement, and it's specifically extraordinary ability or achievement. So when are we talking about ability, and when are we talking about achievement?
This is the funny thing, right? This is the funny thing about all of the OP and the EB-1, visas. Like, if you read the regulations, you have all of these definitions about, what is distinction, what is extraordinary ability, what's sustained national or international acclaim, what does extraordinary achievement mean? I, do not think about those overall, standards at all when I'm preparing cases. And the reason I don't is because I don't think USCIS does. I think when there's a question about like overall does somebody have sustained national or international acclaim, they I think they back into the logic of that instead of actually sort of analyzing on the whole. Like 95% of the time, if I get 3 of the categories in the O1, any of the O1 categories, I'm going to win the case. So regardless of, the overall standard, I really think it's a matter of, do you have the evidence that actually satisfies the regulatory criteria? If you do, and it's sort of at a high enough level, you're not gonna have any problems with the overall standard. I think it's a different issue in the EB1 context, but it often is similar, I would say. So, but primarily, I look at the evidentiary criteria instead of the overall definition, because I don't know what it means, and I do these visas all the time. I really don't think USCIS knows what they mean.
Right. Yeah, or at least it's malleable.
Yeah, exactly. I mean, the way I describe it to my clients is like those standards mean that over the course of a period of time, you have a sufficient amount of evidence in these categories to show that you have been both active in the profession and you have been, understood to have been doing good things in the profession during that time period. That's sort of the way that's the way I sort of analyze it internally. So that's how I sort of tell them.
Got it. And you mentioned that the duration of the initial grant is up to 3 years for both the O and the P. If you had someone coming for let's say you had someone coming to do a movie or something and you're expecting the shooting to take, 1 to 2 years, would you typically request the full 3 years, or do you try to align it with sort of, the projected duration of the project?
Well, maybe the secret with the all of these visas, particularly O's and the P's, is that if you have a lesser period,
Mhm.
my general sense is that you get a or if you request a lesser period, my general sense is that you get a slightly different adjudication. Um, so, like for example, when I do musical artists, if somebody's coming for like a 3 month tour, it's a much less concerning approval for USCIS to be like, okay, well, this person's coming in for 3 months and then they're going to leave. So I find that it's a whole lot easier for them to approve it. So where possible, I want to sort of limit the approval to only what's needed. But it depends on what sort of how the actual case is structured and what the person wants to do. So if like, an artist tells me, hey, I want to, I'm going to come and do this film shoot or whatever, but I also want to, have the opportunity to do this and this and this. What I'll try to do is actually accommodate that by how you structure the case, and add in the manager serving as an agent plus multiple employers, so that we can extend that period to the full 3 years, so that they can actually do all the things they would like to do. So it's sort of a balancing act between like what the person actually wants to do, how much time we have between when we're preparing and when we're filing and when they need to get here, and overall what I think in terms of how strong the evidence is, and what I think USCIS is going to do.
Gotcha. Let's encapsulate sort of the criteria for the O1 and compare it to the P in terms of
Sure.
the eligibility and the application process.
Okay. Well, O1s, basically, well, O1As break down into 8 criteria: awards, memberships and associations, published material about the person, original contributions of major significance, judging the work of others, scholarly articles, critical central capacity for distinguished organizations, and high remuneration compared to others in the
Yeah.
field. Look at that. Just comes straight off the tongue. Um, the O1B categories are so the thing to remember about the O's and the P's, and this is what I tell
Mhm.
people all the time, is the O1 categories are identical to the P1B categories, except instead of the individual having to prove each of the categories, it's the group, the entertainment group that has to prove the
Mhm.
categories. So, it's basically, performance in a lead starring or critical role for productions or events with a distinguished reputation. It's national or international recognition for achievements. It's a lead starring or critical role for distinguished organizations. It's significant critical acclaim or commercial success, high remuneration. And I feel like I'm missing one. It is basically the media about the person and their achievements in the field is the last one for the O1Bs and for the P1s.
Gotcha. Now, as with a lot of the non-immigrant categories, there's in employment-based immigration, there's a corresponding immigrant category. So the O1 criteria sort of mimic, in many respects, the EB-1 extraordinary ability, which is a permanent immigration category. Can you talk about how closely the O1 criteria map onto the EB-1, and how good of an indicator, if someone is held an O1, how good of an indicator is that they might be eligible for the EB-1, and could there be any reason why they wouldn't be?
Yeah, it's a good question. And when I convert O1s to EB1s, it's really easy to convert an O1A to an EB1A, because the other than critical or central capacity to leading a critical role, the like, they're very similar arguments. So it's basically the same language and the same categories as the O1A. O1Bs, it's a little bit different, but what you pick up in the EB1 with that you don't have in the O1A is that you have the ability to use what are called artistic or athletic showcases, which generally are going to give an artist or a performer or whoever it is at least one of those extra categories. And if it's a particularly strong performance, like you're gonna be able to make an argument for leading a critical role. Here's a good sort of breakdown for it. So I do a lot of EB1s for uh, circus performers who are in the United States on P1s. Many of them have like a successful athletic career in like gymnastics or acrobatics or trampoline or whatever it is before they actually come and do the performances. And this includes like, national team level, international competition. So a lot of them are going to have awards, which you can't get on the O1. Well, you can get it on the O1B in, national international recognition, but it's a little bit of a shoehorn. But we have membership in associations because they were on their national team and were selected competitively in order to do that. We don't get a lot of pushback on that argument. Media tends to be one of the harder parts for some of the performers that are in parts of larger groups. But if it's actually an individual who's really talented, they're going to have media from the time that they were an athlete. They're probably going to have some media from the time that they were have been a circus performer. That will certainly work. USCIS will push back on us on leading a critical role every once in a while because they're basically saying, "Hey, well, you're one person out of 80 in a production. You're on stage for 10 minutes or whatever. That maybe that's not a leading a critical role." But we always have the ability to bring in the former like athletic career. So basically, all of that to say, there are often a lot of opportunities to use the argumentation on the O1B side creatively. As an attorney, it can be frustrating because you're basically going to have to go completely repackage the argument because the evidence slicing is done slightly differently on the O1B context to the EB1A. So basically, where before you basically have to link the person's name to the particular productions, you actually have to go back and argue, hey, this is a leading or critical role, or hey, this is media about the person, or this is an artistic showcase instead of the other way that you would present the evidence.
Gotcha. Well, what are like? Let's talk about some of the most common challenges. I mean, I'm sure each of these criteria, and you could see USCIS coming out with a request for evidence. I mean, I certainly stood in back, a long time ago when I was in practice. I mean, and I did these types of visas. You would see, if you're talking about press coverage,
Is that how you started, by the way?
yes. I mean, I was yeah before Doctor Wise, I was in private practice. Yes.
You're living my dream. Come on.
Okay. I'm glad to hear that. Okay. Yeah, that's great. Thank you. That's very flattering. Um, but I mean, some of these because you can see, that where they could question some of these categories. Like if it's major media exposure, press coverage, they could come back and question, the circulation of the publication and all of these. They get into the weeds on these issues. But I mean, what are some sort of like repetitive or most common sort of RFE issues that come out when you're talking about, let's say, the O1?
This is sort of the entire focus of my practice since the last Trump administration is like, how much can I limit these opportunities for RFEs? I mean, what I try to do is lock down particular categories where it's hard for them to argue that. So, like, I find the judging categories particularly hard for them to push back against because, like, if it is judging and it occurred and you have evidence of it, there's they can say, hey, it's not you haven't determined the significance of it, but, if we document it correctly, then we're gonna take care of that. Published material, the funny thing is, what I've seen recently, the RFE is on my desk right now, is a push from USCIS to try to, I don't know, uh, figure out their way to create these technical requirements to avoid accepting evidence that's clearly qualifying. So they'll say stuff like, "Hey, you presented published material, but it's from a website, and you didn't include a link at the bottom of every web page, so we can confirm that it's actually legitimate. So we think you need to respond by sending us a web page that or a printout that has the web address at the bottom of every printout." And it's like, okay, well, that's not a requirement. First of all, it's not a requirement. It's, violative of, Kazarian, v. USCIS. It's, a variety of other things, but, it used to be like, "Okay, well, you haven't given us sufficient circulation data," or like, "I'm ignoring the fact that you presented the media publication," or like that the New York Times is a major publication. I find that they're getting more technical. Like, a lot of times when I submit, media to USCIS, I'm submitting 3 things with each media publication. So, I've got the media, and I've also got, initially an about some sort of page saying, what the publication is. It could be the masthead, it could be like the about page on the publication's website. Ideally, and this is mainly because 'cause I'm just trying to be a smart aleck, I try to submit Encyclopedia Britannica articles about the publication. Like, if I have the opportunity, that's the first thing I do because they used to send me RFEs saying, "Oh, well, we don't accept Wikipedia." It's like, "I'm not having you accept Wikipedia. I'm trying to give you extra context." And they were like, "It's not acceptable." So I basically just started sending Encyclopedia Britannica articles
That's
to them.
funny.
So I'll do that, and then I will also, there needs to be a circulation information. You get, media kits are ideal, but sometimes you get USCIS saying, "Well, we don't trust media kits from publications." And it's like, "Well, why don't you trust media kits from publications?" Like, I didn't make that up. They might. And then, the final thing is, something, focusing on the web traffic, normally like a report from like SimilarWeb or something like that. I've had specific pushback on SimilarWeb saying, "Hey, we don't count this as the same as, circulation," and it's hit or miss. Like, sometimes you just get adjudicators who would really like to raise those issues, and I would say it's more of, like, it's more indicative of how they're overall viewing the application than it is necessarily like a hard and fast standard by USCIS. Like, if I submit a strong artist case, same type of evidence, like, identical to a case for, like, an IT worker in, who's an Indian national or something like that. I'm gonna get the case for the artist approved with no RFE, and then I'm going to, instead of getting, USCIS accepting certain categories in the EB-1A context and sort of giving us legitimate feedback of like, "Okay, look, you said it's a leading critical role, but here's why I don't think it's a leading or critical role." I find that they're more likely to put in these little technical garbage arguments, where it's like, "Oh, well, here's why the evidence you submitted doesn't qualify." And it's like, "Well, look, you can disagree with it, but, I think it would be fairer for them to grant the criteria and say, "Okay, the criteria, still doesn't satisfy the overall requirement of sustained national or international acclaim." So that's sort of the direction I see USCIS going in.
Alright. Now, you mentioned that, you're really big on soccer, and that was some of the first ones that that was one of the first sports that you dealt with. But nowadays, are there particular sports where you get, particularly large caseload? And how about with entertainment? You deal mostly with, Hollywood, or you deal mostly with recording industry, or what is it?
Mostly entertainment groups. People will know, I do pro wrestlers.
Oh, okay.
I do some circuses. I do, some, ballet companies,
Yeah.
some recording artists as well, some sports teams. It's quite a wide variety, and then, a lot of conversions to, EB-1 green cards as well for sort
Mhm.
of everybody within that community.
And how about sports?
Mainly soccer. Yeah,
Okay, still soccer, yeah.
yeah.
Now, when you're submitting evidence that, I mean, let's say someone's had extensive, television coverage, and you're submitting evidence of that, what format are you submitting it in?
Are you saying that USCIS doesn't accept that evidence very easily?
That's what I'm saying. Yeah, at least they certainly didn't years ago when I was doing it.
Honestly, most of the time it's stills of the person on screen. If there's like
Hasn't
if there's
changed.
a cryon where it says their name, it's better, and then a transcript of the materials.
So that's still the same, yeah.
Still the same, exactly. We tried over the years, like, sending them links that they're like, "Oh, hey, this is on YouTube," but they just don't seem to trust it, so.
Let's talk a little bit about what's going on nowadays. So, we're in the midst of this incredible turmoil that we're going through the first couple of weeks of the Trump administration, and it almost feels like it's been 2 years rather than 2 weeks, or
Has it
let's
only been
say
2 weeks? Oh my
two
god.
and a little more than 2 weeks, but it feels like years at this point. Have you detected from your perch any effect on approval rates or any activity with regard to RFEs, visa processing times so far for the cases that you're dealing with?
No.
Okay. All right. Well, that's good. That's good.
Yeah, I mean, I'll say that with the context of it feels like everyone on both sides of the equation are afraid of where things are going. I keep a very focused ear to the ground on consular issues as well. Um, I've had to push a number of cases through in the past couple of weeks, steady as she goes, but nothing particularly meaningful. I would say, at the end of the Biden administration, processing for O's and EB-1s and EB-2 and IWs, as a lot of people know, became a lot harder. So, a lot of times these categories can be very difficult and were very difficult in the prior Trump administration. The prior Trump administration, if you look at the data, like the approval rate on average, or I suppose across all of the cases, only went down about like 4%, but the RFE rate went up by about 30%. So that's sort of what I'm expecting again. It just hasn't sort of materialized yet. Or maybe I'm just lucky.
But is there noise or rumors of any executive orders that you think would directly impact your caseload? And were there any you mentioned, I imagine the travel ban, like the Muslim travel ban could have had an effect on you if you were dealing with any, clients from the affected countries. But were there any executive orders the first Trump administration that did affect you? And how about rumors of ones this time around?
I think Buy American, Hire American affected everybody,
Okay.
for the most part. Just the increased, I don't know, attitude of scrutiny, made some of the things harder. Like, I think the processing of the O's in particular, like, I had USCIS, last time around tell me that, the New York Times, like, sports, like, front page was not, a major publication, like, just because they
Wow.
seemed like they were being mean at the time. Yeah, so there were periods in which bad things would occur like that. I'm a little concerned that the administration is going to be, I don't know, more quieter about, how they're going to process, and add scrutiny. Like, there's an executive order that they issued that basically said, directed, USCIS and Department of State to further scrutinize visa applications. So I mean, that may be them doing it without a lot of fanfare, though, given how they seem to like the marketing efforts, it would surprise me if that was the only thing that they would do. So that's sort of where I have my ear to the ground. The other thing that I think is happening to everybody, and certainly affects these case types, is that there's a huge rush of cases from basically November and December, and USCIS, like, uh, seems to have missed the premium processing deadline on, like, hundreds of cases. And, there's been cases transferred out of the Nebraska Service Center to the Texas Service Center to try to get them adjudicated. But I've been hearing from people online, it happened to a couple of my cases as well, but, hearing from people online that their cases haven't been processed, haven't been touched since December. They filed under premium processing. I actually got a refund check for one of my clients as well, which has already been received. So clearly the refunds are happening, but, something sort of occurred in, November and December that resulted in that for, EB-1 processing for sure.
Are you doing anything differently nowadays compared to, how what you would have been doing if Trump hadn't been elected? I mean, is there any preparatory steps that cautionary steps you're taking?
So I would say the first Trump administration was a really formative experience for me. Um, the way I prepared cases, got very, I don't know, defensive in the Trump administration, and I'm basically submitting these monumental cases that are 1,000 pages long, and they're 1,000 pages long because I'm documenting, each of the aspects so clearly. That has stayed the same since the prior Trump administration, and I'm gonna do the same thing until, it stops working. So I'd say that's sort of the thing that stayed with me, and that's how I'm continuing to prepare. Because overall, I would say when scrutiny increases, the thing that lawyers need to do for their clients is make sure that you're being as focused as possible. You're getting the documents that are very responsive to the issues that you expect USCIS to have. You can't rule out every request for evidence, but you can prepare your cases in a way that makes it less, uh, interesting for them to, file the request for evidence, because they're like, okay, look, you're going to be this guy who's going to do, a crazy response instead of the person that they would ideally like, which is the person that you send an RFE to and then they don't respond. I think that's what the agency ultimately would like when they're increasing scrutiny is, to increase the percentage of cases that choose not to respond to the RFEs. So in some way signaling that you're the type of person that's going to reply very heavily to an RFE isn't, hopefully identifies you as as the person that they want to send fewer RFEs to.
I mean, one of the things that I think helps you is, and it goes back to kind of what we were saying, that it's a bit of a privileged niche, is that, you're not subject to a lot of the invective that some of the other immigration categories are getting. I mean, you don't find, sort of the administration or the MAGA base or, clamoring against, O's and P's the way they
Oh
do
man,
against
when the
H-1Bs
H-1B
and
discussion was
PTS.
happening like a month or so ago, some people started mentioning O's, and I was like, everybody shut up. We're not talking about O-1 visas, but for that exact reason, everybody calls it sort of the Einstein visa, which I'm like in the media, it's like, okay, well, it's not. It's just a very useful category for a variety of different things. Please don't touch it. It works well. It works well the way it is.
Are you aware of other countries that have any other countries that have a similar category to our O visa or our P visa?
Most of the sort of Anglosphere countries, they don't have sort of an exact, like, quality for quality visa category, but they have, like, similar types of concepts. So I'm aware of the general process in the UK and the general process in Canada as well. Honestly, it's easier than what we're dealing with here. It's similar in certain ways, but it's easier in certain ways, because I think ultimately with the US, the concern is always everybody wants to come to the US. There's a higher likelihood of fraud as a result of that. And that's certainly true for some of the other countries as well. But I've seen I've seen athletes get visas to go to Canada to play, and it's more collaborative. It tends to be easier. It's done electronically. No offense. So, I think the systems work a little bit better. I would say the sort of old tribunal system in the UK when somebody's trying to bring over a player that's not from, a list of countries that they typically, have relationships with or whatever, that can be a little bit harder, and I think that's a whole lot more like, what we deal with the O1, which is basically like, okay, well, if we're gonna bring over this person who's from this other, a lot of times it was like South African and, or I mean, sorry, South American and African countries, you have to go through this extra standard of proof in order to actually get the visa to play in, like, the Premier League or the Championship or whatever, so that's a whole lot more similar to what we're dealing with here, which is like, "No foreigners, you have to really prove your case."
Let me ask, let's look at things from the vantage point of the industry, the sports and entertainment industries. I mean, do you think that our current climate around immigration right now, the rhetoric and some of the actual changes, do you think it's having or is likely to have an effect on the industry's ability to attract international talent?
I think attracting international talent is rarely the problem. Like, I think everybody always wants to come to the US. Obviously, it varies in some sports and in some, like, entertainment areas, like some of the, you know, you're gonna a lot of times the top leagues in Europe for soccer, for instance, are going to get, the primary focus or whatever, but the US, leagues are, very popular for a reason and, have folks coming in, quite a bit. Um, I think that the thing that the politics and the thing that the rhetoric does is maybe it has the US miss out on opportunities, not because the people don't want to try, but because the people get caught up in, whatever processing, malaise is hit. And as a result of that, they get denied and they have to go do something else instead. So I would say it's more of a possibility that they miss the opportunity because I still think, most of the entertainers and most of the artists, like this is the place of innovation. It's the place of, the media capital of the world. From that perspective, most of the big organizations are still going to get people in, and that's not going to be a problem. It's just what are we going to miss out on because we're being more stringent with our requirements.
So, and just let me get your opinion. I mean, even though you're working in a specific niche, I mean, just looking more broadly, I mean, how do you feel in general about, the implications of what we're currently going through in immigration policy shifts on US's global competitiveness, just as a general proposition?
I think that closing our sort of, doors and saying, the problem is coming from the outside is, uh is short-sighted. This is, the globalization that's happened over the past, I don't know, what year is this, like 50, 60, 70 years. It is a movement that has changed the face of how we do industry, how we do, entertainment, how we do everything. And the idea that we can sort of put the genie back in the bottle by, closing up shop and, changing some business practices, I think is a little bit, of unlikely to succeed. So, what we have to do, and I think this is something that both parties should it would be great if they would get behind. Our law is from 1965. It was updated significantly in the late 1980s, and the early 1990s. Like the O1 categories, the P1 categories, the EB-1, regulations that we're dealing with have not been significantly touched since, like, 1990. The economy is different. Our needs as a country are different. What we need to do is actually define what we would like immigration to achieve in the United States. Like, there are programs that are very successful. If you look at, like, the Conrad 30, physician program, it is one of the most successful immigration programs because they identified a need and created a system that works really well to provide for that need. So, I think there needs to be some good communication with business owners, with entertainment groups, with artists, with communities, and actually figure out what we need, which is a way to access temporary labor when we need it, and all of the other categories of visas that we have, and actually do it in a modern way based on what the country needs now, and creating a system that allows it to be updated over time so that we don't get like a law that's been on the books for 70 years and can't be updated because it's too much of a political firestorm whenever you talk about it.
Yeah, I mean, we're not having a debate that's a debate about what we want our immigration system, what immigration policy should be in terms of maximizing the benefits for the economy and for the population. We're having a kind of a funhouse mirror reflection of a debate where the debate's been kind of hijacked. The debate's been hijacked, and that's affected not only, talk about the border, but also just talk about immigration more generally. I mean, there's certain things that I think a broad, swathe of the U.S. population and U.S. industry would agree that we want. We want to attract highly talented people here. We want to attract the very best people to the United States. We do want to have a means for people to come in to fulfill, some labor positions that most American citizens are not thrilled about taking, like with whether it be agriculture or some other, jobs that just are not the most sought after jobs. It's good to have a mechanism to have labor for those positions. Um, and we want to, we want the border to be secure. And we want to act in a humanitarian way, or at least most of us do, to the extent that it's sustainable. I mean, but that's not the debate that we're having.
Right.
So,
No, exactly.
and like you said, many of the laws came into play at the very beginning of globalization. I mean, globalization is really got underway very late 80s, around let's say 1990 to make it a round figure. So we're talking about like 35 years of globalization at this point, and like you said, many of the laws date from that time period. So, I mean, we're not properly tweaking. We should be tweaking the law. We should be tweaking the existing laws to enact or create a system and enact policies that facilitate achieving what we want the immigration system to achieve for the United States. But that's not what we're doing right now. It's not what we're doing. The debate has been hijacked, for other purposes, for political purposes, for power grabs and things like that. And it's really unfortunate.
Well, yeah, and I'd say that the way that the law was created, like, originally, it was a reflection of our experience with World War II and our experience with, like, the civil rights era occurring right around the same time. So, the way that the humanitarian, aspects were created, we're sort of looking at the Holocaust and looking at, what happened in that era and saying, "Hey, we don't wanna do that again. That was we feel bad about how we handled this." And, understandable, but obviously the entire situation is different now. And then you look at the way that the individual, like, non-immigrant visa classifications were crafted, and it's like, how are we putting in, these categories that are only updated by, like, internal guidance because you know, the jobs are completely different than they were back then. So, it's dealing with different economic realities and also, out of concerns for brain draining other countries, which, is certainly something that can motivated the folks who were creating the INA back in the day. But the question is, hey, is that something that is still important to us today? Or, are we interested in, bringing over the best and brightest because it helps us innovate, it helps Americans get jobs, it does all of these things. If we determine that's the case, we need to change the law so that it's better at identifying and selecting those people.
Yeah, absolutely. I mean, and that's just, it means that, people need to be much more engaged in the immigration debate and definitely need to get involved so that the terms of the debate can be shifted to substantive issues. But I mean, I think right now it's hard to accomplish that. But it really means that we need more activity, more activism, more involvement of people, to try to get us, back onto the path where we can actually discuss some of these issues. I mean, there's plenty of things that need to be updated in the immigration system.
Mhm.
There were already a lot of things that need to be updated, whether it's how applications are submitted, e-filing, other things like that. Um, all the way through both the laws themselves as well as the system itself, but, it's hard to accomplish any of that in an
Are you saying
atmosphere.
wait, are you saying that there's something wrong and inefficient about this?
Yeah, there you
It's
go.
unbelievable.
It is unbelievable. It is unbelievable. It's unbelievable, and it makes me think back to the early years of when I was actually in practice and you're going to immigration court and they were still using cassette tapes, and this is many, and it was actually hard to believe.
Well, you'll be
But
thrilled. They've basically gotten rid of the fax machines, at USCIS. So I mean, they still have them, but they don't send RFEs via fax anymore. So at least they're updating something, or at least
okay,
not
at least
using
we're
it
at
anymore.
least we're out of the '80s. Right. A fax machine, yeah, technology from the '80s. Let's talk a little bit about, if whether there are any specific ethical considerations that, go into the sports and entertainment industries and dealing with those cases compared to, say, other aspects of immigration law. What types of ethical issues do you find coming
Mhm.
up in your need?
Yeah, this is a really good question. The one that I thought of immediately was where you represent multiple teams in the same sport. Sometimes it happens that a team signs a player, and as a result of your good advocacy, the USCIS processes the case faster and the visa's issued early. And, what happens when your work, gets somebody into the country right before a game against another one of your clients. And, but, because you went so fast, it looks, at least to some of the people, like you moved the case for them faster than you moved the case for the other client. And that can come up, and I think it creates an interesting sort of idea of a conflict of interest where it's like, okay, well, I'm advocating for my client as strenuously as I can, which sometimes results in USCIS or the State Department processing a case faster or slower, depending upon where they're applying from and what the analysis is on the agency side. It can put you into real conflict with other clients within the same league where it's like, oh well, this person just got in, and as a result of that, they scored a game winning shot or whatever against your other client, and it's like you're gonna get a call from the client who scored against, and say they're gonna say, why did you process that so fast? And it's like, that's something that you're gonna have to deal with quite frequently because, they're competing against one another. There's a lot of money at stake, and I think that's one of the areas that is not frequently identified and discussed by other practitioners in this area because of the way that, you know, I think the actual leagues and the teams are typically represented. It's a lot of the same lawyers doing a lot of the same teams. So as a result of that, that comes up from time to time, and I'm not sure that's realized at the bar more broadly.
Mhm. Anything else? Any other ethical issues? That's your main concern?
I'd say that's certainly one of the concerns. I mean, the
Yep.
other thing that comes up a lot of times
Uh-huh.
is when you're practicing at a high enough level in terms of like sports and entertainment, qualifying for the visa is not the issue. Like qualifying, you submit the application to USCIS, you're confident it's going to get approved. The question is how quickly is it going to get approved? And one of obviously the ethical dilemma that comes up, from that perspective is like how much am I able to push? What am I able to say? Who am I able to contact? What other assistance am I able to generate from congressional or senate offices or within the administration itself to motivate this approval? And where are the guidelines for, like, I don't there's to my knowledge, there's no guidelines saying what I can and can't do from that perspective. So you have to sort of define that internally and act in a professional and ethical way, because you know it's a powerful tool, and you have to use it correctly and try not to ruin it for everybody else.
Mhm. This might seem like a kind of a slightly wild question, but, you know, people, the entertainment industry and sports and, people in those industries, they like to have a good time, let's put it that way,
Oh
athletes in
God, I know
particular,
where this is headed.
and, frankly, I'm thinking about the grounds of inadmissibility, and I'm wondering whether, there are any particular. Now, I didn't see it, back when I was in practice, but, were there any particular grounds of inadmissibility that tend to come up more commonly with these folks rather than other types of cases?
Well, certainly not from my clients. My clients clean, the best people. Just to be clear, none of them have any problems whatsoever. They're wonderful citizens. Um, if I were to pose a guess about other experiences that people may have, principal ones are drinking and drug related, and criminals issues like drunken assault and domestic violence types
Domestic
issues.
violence, perhaps
Yeah.
DUI or
Yeah,
DUI.
yeah, yeah. So I mean, what you're seeing more broadly in the entertainment and sports space for Americans, it's the same deal for everybody else.
Yeah. Okay. It's pretty much what I thought. I kinda
Yeah.
wanted to just
Yeah, I mean, if you have, like, a sometimes you get sort of weird, inadmissibility issues, like, I within the era of, like, DACA and things like that, you'll every once in a while, you'll get, like, "Oh, well, this person's, like, undocumented and, was very successful in college," and, well, all of that, those sorts of issues. That's a lot rarer. The garden variety stuff is like, I got arrested because I was drinking and, like, firing fireworks at somebody or something like that.
Do you think it's feasible for an attorney in the in sports space to, like, focus. I mean, you're focusing mostly on soccer. Let's say someone was gonna do just sports, you think it's feasible to focus on one particular sport like that and make a whole niche out of it? Like, somebody wanted to be like I don't know, the boxing attorney or the golf attorney, and any examples of that?
Yeah, they exist. The golf attorney is Steve Laddick in,
Oh,
Dallas.
right. That's true, and I do know
Yeah,
that name.
the track and field attorney is Ksenia Mayorova, in Florida. I mean, the god of music immigration is Leah Kushner. She's a legend, obviously. There are a variety of there's a guy who, I met in, Arizona last year, the year before last, who a lot of what he does is just like professional bull riding, which I didn't even realize was a thing. He gave an entire, like, panel on it. It was fascinating because, his primary niche is just professional bull riding. You got MMA people, uh, principally focused in sort of the West Coast area. Northeast is a lot of the pro sports. Don Moore is obviously my colleague in Maryland, has done a lot of the soccer related immigration over the years. It can certainly happen. The diversification of practice is always a little bit interesting because the the thing about entertainment in sports is it can come and go. Like, you can be amazing at it, but the clients will sometimes not be happy and will want to seek other opinions if things aren't happening fast enough, or if they're getting results that they don't like, because they're people that are in organizations that people really want to vie for in terms of representing them. So I mean, I have sort of a corporate practice as well that goes along with it, but yeah, I it's certainly possible.
So are you operating in the entertainment law space as well as the immigration space, or is the corporate
No,
practice?
no, I'm all immigration. I'm all immigration.
Okay, okay. Well, what's the corporate what did
Oh,
you
so
just
yeah, I mean, I just do standard corporate immigration as well. So I do a lot of
Oh,
like
okay.
L1
Gotcha.
blankets, H1Bs, or not as many H1Bs, but perms, all those sorts of things as well.
Okay, I understand. Yeah.
Yeah, yeah, yeah.
Okay. So let's take a look at like a future outlook here. So, do you expect any more changes coming down the pipe? I mean, are there particular changes or any policy shifts that you're expecting with regard to these categories?
I mean, it's gotta happen, right? I mean, it's hard to sort of predict exactly what they're going to do. I mean, my general assumption is that we're going to see a tightening of like adjudication standards across these categories. I mean, I do think it tends to flow within like an occupation or industry based like paradigm. So like, O1Bs for artists, for major organizations, they're not gonna have problems. P1s for athletes at major organizations, typically not gonna have problems. Like, there may be processing hiccups every once in a while, but the ones that are gonna have issues are sort of the smaller arts organizations that don't have the ear of, the agency or politicians, or it's going to be, folks in, less preferred, nationalities or less preferred, like, sports. Like, for example, it's been hard for years in immigration law for like MMA athletes or jujitsu athletes. Like, that's going to continue because the overall concern is pushing fraud, 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 and there's an agency predisposition that doesn't like that. And same deal for like nationalities where USCIS is potentially looking at like somebody getting out of a visa backlog. So Chinese nationals, Indian nationals who are applying for EB-1, they're gonna get a different experience. They've got a different experience during the Biden administration. They typically get a different experience than all of my other clients generally. So, I expect that to just continue because, where once scrutiny is ratcheted up at an agency, it's very difficult to ratchet the scrutiny back down. What tends to happen is that the ratcheted scrutiny on certain categories get transferred to other categories. So, like, the only main, change the last time around for P1s, it was scrutiny on, the solely to compete issue, which is basically like, "Hey, we're concerned that people are gonna come and do coaching or do, like, training aside from competing." And then the second one was they saw a lot of fraud in the P1S category in certain sports, so they limited the approval period for initial P1 so they could basically come back and review it a year later and make sure that the person wasn't actually committing fraud. So, little fixes like that very likely, the main aim again, make the process a little bit more difficult, cut out some applications when they have it, and then the overall focus is again on ratcheting up the look at potential, exaggeration or potential fraud instead of, whether the person actually qualifies.
What's some advice for applicants nowadays? I mean, given the climate that we're in, are there specific tips that for how applicants can best prepare themselves for visa interviews, and what are the common pitfalls that they should look out for?
The biggest one that so it's there's become an ecosystem of like, profile creation for, EB-1s and EB-2 NIWs and all of that. Um, That is sort of advice that immigration lawyers have given for many years in terms of, like, how to actually develop your case and make it better. The thing that I know USCIS is on the lookout for is, like, what I call astroturfed media or astroturfed documentation. Like, if you're paying for media, if you're paying for things that make your case look better, but aren't actually, like, delivered organically or created organically, that's the thing that they're really queuing on. The other thing is that, I communicate from time to time with people who I know are USCIS adjudicators in these categories, on sort of a I don't know, a friendly basis, and what I hear from them all the time is, "We're getting boatloads of crap AI generated large blocks of text, and it's
Sure.
making the adjudication process really terrible." And, the funny thing is, I feel like I went through a period of time where it was like, "Okay, I wanna make my petitions longer because I want to just hammer them with everything I've got." And I think what the sort of generative AI situation has done is it's making me go back and say, okay, instead of I want this to be as long as possible, it's like I want this to be as direct as possible so that when the officer is scanning through it on, the scan that they have now, because they don't we waste the paper, they scan the paper and then they actually review it. They can actually see what I'm trying to say and hopefully are getting less frustrated with me instead of, I send them 1,500 pages and it's like, okay, well, where's the stuff I want to see? So I think, over documenting, you got to do it right. And you can't hack your way into an EB-1. Like maybe you can, still like, it's certainly possible that you get through, but the bar is becoming higher and they're looking out for it more. And it's harming the rest of us. So don't, submit real stuff.
You said something very important, which is there's a difference, and all immigration lawyers take this to heart, between thoroughly documenting and over documenting or adding superfluous material that isn't really helpful to the case. And actually, when you do that, you're running the risk of, obscuring the really important material or having it get sort of lost in, in an overabundance of things that aren't that important. So there's an art to that, and it's a skill, and it's something which, develop over time, but it's something to watch out for. And then with the AI, God, I mean, that is just something which is practically all lawyers and all industries should just take that to heart. I mean, the best illustration of that, I saw a cartoon, it was sort of like two panels. It was like two, it's one person at a computer talking to someone else, and another panel with another person talking to. And the first person said, this AI is great. It turns the few bullet points I have into a full email that I can pretend I've written. And on the other side, it said the person's like, this AI is great. It takes this full email and just reduces it to a few bullet points so I could pretend that I read the email. So it's like, what are we doing here? But yeah, I mean, certainly, I mean, God, I mean, use AI strategically, use it effectively. It's really a very powerful tool. But I mean, for God's sakes, there's a lot of learning resources out there for how to properly use it. And the way to use it is not to just generate a lot of redundant language or redundant argumentation or verbiage that you put into your filings, because God, I mean, certainly, again, it risks losing your important points. It makes you look really, bad if the person who's reading it realizes that it was just AI generated drivel.
Yeah, I feel like we also need to maybe create some sort of certification that's like, "Hey, here's a sign under penalty of perjury. None of this is AI generated." It's like, I don't know if it'll help, but it's basically like, "Oh, yeah, this was created by our own hands." I don't know if it creates a higher value, but maybe it sends some sort of message.
Yeah, I mean, that's the whole question is, I mean, I think it's something which, regulatory authorities and courts and so forth are they're gonna come to the right place with that. You see, it's an the question of regulation of AI tool use by lawyers is something I'm very interested in. We've talked about that on other episodes of the podcast. We're going to continue talking about it because it's so important. But you see a variety of approaches being taken by the regulatory bodies where it's pretty minimal, like, you sign off saying, "Yeah, if I used AI, I personally checked all the citations and checked everything." All the way up until like a prohibition by some courts on any use of AI or certifications of very specific things. So you see a variety of approaches, and it's something which is going to evolve. But I mean, certainly, again, the idea being you want to harness the power of the tool, but the concerns being accuracy, and then the other concern being, your pride in your work, your professionalism, your personal attention to detail. That really should shine through. The human touch, that it has, the subtleties that the human mind and the mind of an immigration lawyer or other professional who's experienced in a particular field, the subtleties that you bring to that, which aren't going to be replicated when you're churning out boilerplate.
My handwritten notes in the margins of evidence pointing them to specific things that I would like them to look at, They can't I wish somebody could do that for me, but, I haven't figured out a way to do it. One thing that I would also flag, in terms of, like, the AI discussion, um, there's a I don't know if it's a conspiracy theory, but people in our office and people I've talked to, are interested to know if USCIS workers are using AI in any of their RFE generation. Inquiring minds wonder. I know that there's actually like or at least there was. I haven't seen, I haven't looked at it in the past 2 weeks, but there was like an inventory of AI programs authorized for use at USCIS. I know one of them basically like reviewed like I-539s to determine whether or not they were likely to be approved or something like that. So that's a little interesting tidbit. I would be very concerned with AI in its current state making decisions of that nature, but that's certainly something to watch.
It's hugely important. It's another major, major topic that I've been covering on the podcast. We're going to continue to cover is the potential for AI use in adjudications. There's so many concerns, and you hinted at a lot of them. There are biases. There's just inherent biases, or depending on how the AI model is trained. And you can, you know, as well as the I mean, the main one would be the biases, and you can think of the case of how it's very in the news, the health insurance company, United Healthcare, using an AI algorithm to deny
Yeah,
claims. You could, you fear
not
as an
ideal.
immigration lawyer, you just have a sense of dread that the immigration authorities would be using an algorithm to come up with to formulate additional reasons to deny cases. It's something which I think all of us are afraid of. Um,
Yeah,
but on the other
you put in a filing and you say, "Hey, give me 10 reasons to deny this."
10
It's
reasons
like,
in it. But on the
awesome.
other hand, you can think of some instances where, they wanna do sort of a quick overview, like credible fear determinations or something, just to get to the root of what the person is saying, like, say, in an asylum situation, get to the and how does that stack up to other claims that have been brought by other applicants, just to see whether there's a colorable claim there that it could then be passed on for not being the final word for the adjudication, but just an initial determination as to whether there's a colorable claim and whether it deserves to go into the asylum system. That's one instance, one possible instance where I could think, where the tools could help in a high volume situation for kind of finding meritorious, the essence, the kernels of a meritorious claim, potentially meritorious. So, James, let's talk about, what motivates you, and how do you stay updated with all the changes going on in immigration law? What's your favorites for staying on top of everything?
Oh, sure. Well, in terms of motivation, I thought a lot about it, starting about November. I was like, "Are we gonna do this again?" Okay. Um, the biggest ones that I find, I don't like bullies very much, and I don't like, non-transparent government organizations. So, in some ways, when I see an administration that's very hostile to a group of people that I think benefit the United States in a lot of ways, it makes me wanna go defend them. And then at the same time, where I see, our dear friends at the State Department or our friends at USCIS who are, operating these bureaucracies in which people can get caught in them with errors and cases, and I've resolved, any number of errors over the years where it's like, somebody just screwed this up, and I can't get anyone's attention because they're trying to keep me from communicating with them at the customer service line, or they're sending me to a visa navigator, and no one will answer my inquiry or whatever it is. Um, you know, m Resolving those bureaucratic hiccups is something that I find quite enjoyable because oftentimes it's not standard, filing petitions or whatever. It's doing something strategic and creative and trying to get someone's attention to look at a particular issue. And I think that those sort of fixes are very valuable to people and are I always remember them very positively where it's like, oh my gosh, they denied my adjustment of status incorrectly. I'm literally cannot work in the United States. Something has gone wrong. And, I figure out a way and, filing a 290B, getting it reopened in like a 2-week period just because of a little creative strategy, and it's like, "Okay, well, that's that changed that person's life," and it certainly didn't make me the most money of anything that I do, but that's the sort of thing that, hacking my way in and figuring out a way to resolve the person's issue and do it in a respectful way, but do it in a way that, realizes that negative bureaucratic decisions can have real awful impacts for people, and sometimes it's really hard to move the needle on there. In terms of like how I keep up to date, I feel like I have my brain like plugged into my computer all the time. It's Ayla resources, it's Ayla listservs, it's talking to my clients, my larger clients, seeing what they're seeing. It's seeing my own case flow and analyzing, what I'm seeing in particular decisions in terms of timelines. I keep like spreadsheets of like processing times and like specific decisions and consulates and all that sort of thing. And it's talking to people, it's being on social media, it's looking at the news. Fortunately, the EB-1s, O's, and P's regulations don't change that often, but what changes is the particular interpretations of, some of the evidence in certain types of industry categories. So, like, there was a period in which for entrepreneurs, we would have a lot of success making the same arguments every time in terms of like investments as awards, accelerators as memberships and associations. Over the past, 3 years, that has shifted in a way that like it makes us somewhat less comfortable in terms of analyzing and filing those cases. We'll still do it, but the prognosis is not as good as it used to be, and getting each of those individual nuances is something that you're going to get from filing cases over and over again and seeing what the agency actually does, and then like you know learning lessons from the cases that you file and how they're treated.
Mhm. I mean, there's issues that I can see. Well, first of all, let me just share a couple of tips for coping with the current environment that I'm using. These are my personal favorites, which is like consume information about what's going on in immigration and just going on in the country overall. Consume it, but I personally, what I'm doing is consuming intelligently sources that I think really add something to the debate rather than just listening to things that sort of are rehashing, all the horribles that are going on over and over again on a loop. Because I think all that does is kind of bring you down. And I think really, if you're smart about your sources and you're listening to information, which is really lending to a greater understanding, I think that's the way to go for me personally. And I would suggest that. Um, but certainly, in terms of things that looking ahead, what's coming down, do you have any concerns about things that not specific to the OMP, but like more generally, this more general anti-immigration line and some of the other policies? Like, let's say, for example, I mean, some of the issues coming out with the anti-trans, I mean, that affects a small number of people, but it's a significant effect on them in terms of, their immigration, their identity documentation. I mean, just now we found out that the State Department is not going to recognize X as a gender neutral, marker on U.S. passports. That's an issue for the people that, I mean, there have only been, I don't know, there's some number of thousands of passports that were issued with that marker. I mean, it's not a gigantic number, but for the people that are affected, it's very significant. So I'm just, there's that issue, and then there's, the potential for some of the other issues. I mean, let's say, for example, I'm thinking also same-sex marriage. That if that were ever overturned, that would be a huge disenfranchisement of immigration benefits for a large number of people. So, I mean, I can see some of these other potential social issues, but coming into the immigration debate as we progress along.
Well, yeah, I'm particularly concerned as well about the like freedom of speech issue regarding like visa holders. That is
There
obviously
you go.
something
There's another
something that
important.
the administration has said. Hey, we want to evaluate people who are on student visas and whether or not they're protesting or taking actions that do not violate the law here and in fact are protected by the Constitution. Um, the Visa applications for, I don't know, since I think it was like 2018 or something like that, have been collecting social media data on visa applicants and, to my knowledge, generally not using it, but aggregating it. And, those aggregation systems and those databases can be used to identify and evaluate, somebody's um, uh, online speech and potentially affect somebody's visa adjudication. I think that's very problematic because, it doesn't make a lot of sense for the United States to invite people into the country and say, "Hey, well, even though everybody else is protected and can do what they would like, we would like to constrain your speech." Because it reduces voices. It makes it more problematic for visa applicants, and um, it also makes another creation of the surveillance state that maybe then is subsequently transferred to the United States. So, very It's very concerning. It creates the exact type of, chilling effect that most, regulations of speech are, prevented from in terms of the government, decisions.
Absolutely, and it also brings into play mentioning the social media collection of social media data on visa applicants reminds me again of the AI issue where you can see, algorithms, being used in a way to identify people who have, made certain kinds of posts on social media or voiced certain views and things like that. I mean,
Well,
I would not.
I'll tell you a story about one that's a little bit interesting. There's an organization in, I think it's the Department of Homeland Security, called the National Vetting Center because, of course, in immigration law, we need 2 NVCs. We need the National Visa Center and we need the National Vetting Center because that's not confusing. But basically, the National Vetting Center, what they do is, they're the organization that's responsible when somebody applies for an ESTA of sort of doing the evaluation of whether the person should be qualified. So, sometimes I'll be contacted because, say an artist wanted to come in for the weekend or whatever on ESTA and happened to make a social media post of like, "Hey, I'm really excited about playing this club or whatever." And, they got an initial ESTA approval, which is done, essentially automatically. And then somebody went back in because some sort of aggregator that they have, and they have social media aggregators systems at Department of Homeland Security, it flagged the post where the person indicated they were coming in to play at a club and denied his ESTA and wasn't able to get in as a result of it. And that's a very significant concern that they have the capacity to do that. So you apply okay, well, that person was, going to work in an unauthorized way potentially. The pre-crime version of that to freedom of speech, and it's like, oh well, hey, this person liked these posts about X, issue. Does that then render them, unable to get an ESTA because the government decided that we don't like that viewpoint? I think that's a real problem.
Yeah, especially when they've explicitly talked about ideological screening. It's been made explicit that they want to make use of additional ideological screening to filter out people who have viewpoints that they don't like. Um, so it's something to watch along with many of these issues. But, yeah, but we're coming to the end of our hour. So, James Hollis, it's been a great discussion. And certainly we'll, have you back to continue to follow developments in the sports and entertainment space as we progress through our turbulent immigration waters that we are swimming in nowadays. But I hope you've enjoyed it, and I've certainly enjoyed the conversation. And I thank you very much for being here on Immigration Uncovered.
Hey, thanks for having me, James.